All right, so Mr. Raines, are you on a file with Mrs. Noe?
No, I don't believe so, Your Honor. I'm here for Mr. Gonzalez on your show cause docket.
Okay. Good morning, Mrs. Noe. What case are you here on? Oh, she just disconnected. Okay. All right, Gonzalez. All right, Mr. Raines, I have a couple people. I don't know who their names are, so let me go through and get names. Is Mr. Gonzalez with you, Mr. Raines?
He is not this morning, Your Honor, no.
All right.
Hello,
Hi, what is your name, please?
I'm Jody Buer.
All right, I'm going to change your screen name. Let me find it here. All right, Miss Beer, I'm going to pop you in the waiting room. I'll be right with you. Mrs. Noe, what case are you here on?
Say again.
Oh, I'm sorry. What is your name?
Cody Ford.
All right, I'm going to rename your screen so I don't lose you, and I'm going to put you in the waiting room. So I'm going to put you on hold. All right.
Your Honor, he was adjourned.
Oh, Mr. Ford.
Yep.
Let me find you here. I don't see Michelle. All right.
January
so
9th.
in the
Sorry.
matter of Michelle Shuck versus Cody Ford, file number 2018-45753 UN. Mr. Ford, that was adjourned to January 9th at 8 a.m. All right.
Thank you very much.
All right. You have a good holiday. Thank you.
You as well. Bye-bye.
Bye. Mrs. Noe, what file are you on?
File number 2149075 DM, Brian Jones.
Okay. You represent Brian Jones?
I do in a divorce, Your Honor.
Okay. All right. Hold on. I'm just going through and getting the names of people that are marked. So just give me a moment.
Certainly, ma'am.
What is your name?
My name is Valen Albright.
Judge, I sent you a chat message about Hayes.
Yep. I saw it. Thank you. All right. I'm going to send a chat to whoever's on the Moto device to connect to audio. All right. And then let me see what else I have. Does that look all right? Good morning. What is your name, sir?
Brandon Nodine.
Say it again.
Brandon Nodine.
All right, hold on one second. All right. All right, Mr. Nodine, I am going to pop you in the waiting room and I'll be back with you in just a moment. All right.
All right, thank you.
And I got one more to double check. Two more to double check. All right. I have someone who's called in on a telephone line. What is your name, please?
Dakota Gilgallen.
All right. So hold on. I'm going to change your screen name so I don't forget it. So I'm going to put you on hold for just a moment. All right. And let's see this Moto device. All right. That's it. So. All right, I have Sierra Strauss and I do not have Jonathan Gonzalez, Mr. Rains. Oh, maybe I do.
Your Honor, he is attempting to log in right now.
Is that him with the hat on?
I can't. Jonathan, can you hear him?
I think it's probably him.
Yeah, that may be him, Your Honor.
All right, I have a gentleman with a hat on. Could you take your hat off, please?
Oh, yep.
Yep, and what's your name?
Jason Stevens.
All right, not who I thought you were. Okay, so Jason Stevens.
Yes, Your Honor.
All right, it's Mr. Stevens. I just changed your name and I'm gonna pop you in the waiting room.
Your Honor, that one's dismissed as well.
Oh, let me bring him back in. All right. Mr. Stevens, I'm
Yes, ma'am.
sorry. I got rid of you too fast. In the matter of Deborah Marshall versus Jason Stevens, file number 2010-35472 DS, Mr. Stevens, that's been dismissed. So you have a good holiday, all right?
Thank you.
Thank you.
Same to you.
All right. I got a Chino. Let's see who Chino is, Mr. Rains.
Hopefully.
Leave.
So I have somebody that says Chino's phone. What is your name, please?
Jonathan Gonzalez.
All right, Mr. Gonzalez, hold on. I got Sierra Strauss. Miss Strauss, okay. So this is in the matter of Sierra Strauss versus Jonathan Gonzalez, file number 20-47405 DP. Let me grab your file. Let's see. All right, so Mr. Gonzalez, we are here on a friend of the court show cause. States here that you're ordered to pay $414 a month in child support. And as of today's date, you have an arrearage in excess of $6,856, which is working its way up to the point where the Attorney General could charge you with a 4-year felony. So the last payment we received was $200 on November 22nd of 2022. So that's excellent. Okay, so sir, you have a balance owed of $214 for the month of November. Are you able to pay that? Or Mr. Rains, I'm sorry, you represent Mr. Gonzalez.
I do, yes. Good morning, Your Honor. Matt Rains appearing on behalf of the defendant, Mr. Gonzalez. Your Honor, Mr. Gonzalez had just retained my services last week, the shortened week. I really do not have much in terms of file materials for him. He has acknowledged to me not only that he has this date today, but that he does have a substantial arrearage, which he is attempting to address. He has very little income at this time because he is receiving an education, and there's some kind of paid training, so to speak, through Legacy Barber College where he's at. But hopefully once he matriculates from there, he'll be able to establish a clientele and begin to work on that arrearage. Judge, I am going to be part of what he wanted to engage my services for was to address the issue of child support at the front of the court level, and there will be a front of the court petition that will be forthcoming. And so, Your Honor, I do appreciate that he has an arrearage, and maybe this matter has been, I don't know the history of it, maybe it's been continued a couple times, but if you would, Your Honor, I would appreciate if this matter could be adjourned for another date. You could monitor his payments. I'd also like to see if I could get his support addressed through this petition that's forthcoming at the front of the court.
All right. Well, I appreciate that your client's going to school, but you know, a lot of people worked part-time while going to school to pay their obligations. So, Mr. Gonzalez, I will adjourn this 1 week, but you need to pay the November obligation in full. I also showed that he had a friend of the court review back in March. So just that's for your information, Mr. Rains. So Mr. Gonzalez, I will adjourn this to December 5 at 8 a.m. for you to make the balance owed on November. So, and I'll continue your not guilty plea, but December 5 at 8 a.m. All right,
Your Honor, that amount is $214, I think I understood you to say.
yes.
All right.
All right, we'll see you back Monday morning. Thank you, Mr. Gonzalez. Thank you, Ms. Rao.
Thank you, Your Honor.
All right, so Jones, I got Carrie Jones and I got Brian Jones. All right, Mrs. Noe, hold on. And you said, Mrs. Noe, you represent Brian Jones?
I do, Your Honor.
All right. All right, this is in the matter of Carrie Ann Jones versus Brian Dale Jones, file number 21-49075 DM of Margaret Noe appearing on behalf of the defendant Brian Jones. Mr. Jones, this is the date and time scheduled for a show cause in this matter. I show that you have a monthly charge of $1,008. And you have an arrearage in excess of $11,456, which is at the felony level and can be referred to the Attorney General's office to charge you with the 4-year felony. And by that, I mean it carries a maximum penalty of up to 4 years in prison. Mrs. Noe, I show that this is a 21 file and he has not made any payments at all. And we've not received any employer information or anything of that nature. Now, Mrs. Noe, how would you have your client, and Mr. Jones, for a first contempt on a child support case for failure to pay child support, the maximum penalty is up to 45 days in jail. And on a second offense, it's up to 90 days in jail. So Mrs. Noe, how would you like to proceed today on behalf of Mr. Jones?
Your Honor, as outrageous as it sounds, my client was not really served in this matter until late in the game. And at that time, the parties or up until about 3 months ago, if not less, parties acted in pro per, both of them. Since then, Mr. or Ms. Jones has, Mr. Stimpson and I have represented Mr. Jones. So a lot of this went unattended. And my client had the children for half the time during that period of time. All this has to be addressed with the friend of the court because my client did not act. My client did suffer a disability that he is now coming out of. However, he's still not able to drive. He's working with Dr. Sherman, but all that's ending and he is intending on working and he's intending on addressing this. I do believe if it's not scheduled, it will be. End story. I'm asking for an adjournment. This will all be addressed. That arrearage, I believe, will be reduced if it gets some credit. So I know it sounds outrageous, but it is going to be addressed.
So you're asking me to enter a plea of not guilty on behalf of Mr. Jones. Do you have a friend of the court referee hearing date?
I don't. I believe that Mr. Jones has one scheduled. I would ask
Mr. Jones, do you know what that date is?
I do not have a date yet.
I think he attempted.
Okay, so Miss
I will
Adams,
get one.
could I have a date, Miss Adams, for the end of January, please?
For Monday morning?
Yes, ma'am.
January 30th.
All right, Mrs. Noe, are you available January 30th at 8 a.m.?
I am, Your Honor.
All right, so Mr. Jones, I will set this for January 30th at 8 a.m.
No, I am not. I'm very sorry. I'm not.
Okay.
Sorry.
Are you available January 23rd?
Yes, I am.
Okay, so we'll set this for January 23rd at 8 a.m.
Judge, I'm
Yeah.
sorry. I don't think friend of the court's going to be available that morning.
Oh, okay, so how about February 6th?
That works.
Okay, we'll do February 6th. Mrs. Noe, are you available that day?
I am.
All right, so we'll do February 6th at 8 a.m. And obviously, Mrs. Noe, if the friend of the court is not yet had a hearing by then, you can call and get that adjourned through the caseworker.
That's the only thing I would be concerned about. That's
Okay.
perfect. Thank
All
you.
right. Thank you, Mrs.
Sure.
Jones, Mr. Jones, and Mrs. Noe. Thank you.
Thank you, ma'am.
All right. You have to tell me your name again, because. All right, let me find you. Oh, you're not a party. Okay, never mind. All right, let's see. Miss Adams, I can get Mr. Ely from the jail.
Did they bring you paperwork?
Yep, I have paperwork. Do you want the paperwork?
I guess if you want me to send it to the public leaders.
I
Okay.
got it. All right, Miss Engelhardt, can you hear me?
Yes, I can. Hello, how are you?
I'm good. Good morning. So in the matter of Beth Ann Engelhardt versus Steven Sancho, file number 2013-39096 UE. Ms. Engelhardt, that has been adjourned to January 9th, so we must have received a payment or something.
Oh, okay, January.
January 9 at 8 a.m.
Right. All right then.
All right.
Sweet.
All right. Thank you.
All right. Have a blessed day, guys.
You too.
Merry
Thanks. Bye.
Christmas.
So, Wilson.
All right.
All right, Mr. Wilson, good morning. How are you?
Okay.
No,
Okay, ma'am, what is your name?
my name is Sharon Moser.
All right, so I'm gonna change your screen name and then I'm gonna pop you in the waiting room, all right?
Okay, this is for Jody Buer.
Oh, Jody Buer, let's see. Okay, all right, I'm gonna put you in the waiting room.
Okay, thank you.
All right, Mr. Wilson, I don't see Tanya. All right, in the matter of Tanya Spiel versus Izell Wilson, file number 2009-34540 DS. Sir, that's been adjourned to January 9th at 8 a.m. All right,
January 9th.
at 8 a.m.
Okay.
All right, thank you, sir. You have a good day.
You too.
Thank you.
Bye.
Bye. The matter of Michaela Emmons versus Michael Hamden Jr. File number 20-47698 UN. That matter has been adjourned to January 9th. And let's see what I got. In the matter of Ronnie Matson versus Latoya, what did we say it was, Jaso? File number 2011-37046 DC. Miss Adams,
Yes.
could you verify with the jail if she's in custody?
Who's that?
Latoya Jaso.
Okay.
I don't think, but I just remember seeing Jaso on the jail list. All right. All right. All right, Miss Buer, can you hear me?
Yes, I can.
And Miss Moser, can you hear me?
Yes, I can.
All right, and you pronounce it Moser or Mosier?
Mosier.
Okay, in the matter of Sharon Mosier versus Jody Lynn Buer, file number 2012-37532UN. This is a date and time scheduled for show cause. Miss Buer, I show that you're ordered to pay $108 a month, $108.33 per month towards your arrears, and you have an arrearage in excess of $10,304. Do you understand that?
Yes, I do.
The last payment we received was on October 28th of 2022 in the amount of $120. Miss Buer, are you able to make your November payment this week?
Yes, I am. It should be today or tomorrow.
Okay, so I'm going to adjourn this to Monday, December 5th at 8 a.m. just to verify that you made that payment.
Okay.
And front of the court, if she makes that payment and you want to adjourn it out to January to monitor the December payment, we can do that. All right. So I'll adjourn it over to Monday morning at 8 a.m. to see if you made the payment. If you have, they may be able to adjourn it. Do you want to make that payment here, or do you live in Michigan?
I'm usually come in and make it in there. I do.
Okay, good. So if you make it in person, ask to see your caseworker, and that would be Miss Fetzer Wallet right there, and verify that payment, and she can adjourn that out to monitor your December payment. All right.
Okay, thank you.
All right. So Miss Mosier, thank you, and Miss Buer, thank you.
Thank you.
Bye.
Bye. Thanks. Mr. Murphy, what are you hearing?
Morning, Your Honor. Last week,
Oh,
I
no
thought you
dine?
had said, yeah, Brandon, no dine.
Okay. All right, hold on one second. All right, Mr. Ely.
Morning.
Good morning. Let me see if I have Megan Freshcorn. No. All right, so this is in the matter of Anthony James Ely versus Megan Elizabeth Freshcorn, file number 2018-45575 DM. This is the date and time set for a show cause in this matter. Mr. Ely, it's a show cause for failure to appear and failure to pay. Shows here you're ordered to make a payment of $1,117 a month in child support. And as of today's date, you have an arrearage in excess of $24,470, which is well above the felony level. And I don't know if this case has been referred to the Attorney General for a felony, but do you understand that you could be charged with a felony for failure to pay child support and be facing up to 4 years in prison? Do you understand that?
Yes, ma'am, I do understand that.
All right, and on a first contempt, the maximum penalty I can give you is up to 45 days in jail. And on a second contempt, up to 90. I show that you don't have any prior contempt, so you could be facing up to 45 days. You were present on the record on October 3rd of 2022, and we adjourned to November 7th for you to provide proof that you had filed for a support review. You did not appear on November 7th, and so a bench warrant was issued, and I do not show that a support review was filed. You did make a $95 payment after the bench warrant was issued. So, Mr. Ely, do you understand that you have a right to have an attorney represent you at this and all subsequent hearings?
Yes, ma'am.
Do you understand that if you cannot afford to hire an attorney, we can appoint you one at public expense? Would you like an attorney appointed to represent you?
Yes, ma'am.
Okay, so Mr. Ely, Mr. Murphy, are you doing our pickups, or is Miss Underwood today?
I was only going to be here for Mr. Nodine, so I think Miss Underwood is.
Okay, all right, so Mr. Ely, if you can just bear with us for a moment. We'll get Miss Underwood here to speak with you. All right.
Okay.
All right. So I'm going to change your screen name. And then I'm just going to pop you in the waiting room. So it might be a couple minutes. All right. All right. I got Mr. Nodine. Mr. Murphy.
Yes.
I don't have a prosecutor.
Okay.
Who's your prosecutor on this one? Phoebe Meir?
Yeah, it's Phoebe.
All right, that's what I've been waiting on. And Miss Adams, I'm sorry to bother you again, but I also, this was set for today.
Judge,
for-
she's on the phone, but I can call Miss Meir.
All right, thanks. All right, so Mr. Nodine, I didn't forget about you. We'll be with you in just a moment, all right?
All right, thank you.
Do you need a breakout room with him, Mr. Murphy?
I don't think so. I think we've talked enough unless he wants to talk to me about anything right now. Do you need to talk to me about anything, Brandon?
No.
All right, I'm
Okay.
gonna pop you in the waiting room.
Thanks.
All right.
And Judge Miss Jaso is not in jail.
Okay, great. All right, so back on the record in the matter of Ronnie Matson versus Latoya Jaso, file number 2011-37046 DC. Ms. Jaso was ordered to appear. She's failed to do so. I'll issue a bench warrant for her arrest. And I will set bond in the amount of $750 cash. All right. Let's see. The line. All right, in the matter of Barbara, let me see here.
Your Honor, I don't know if Ms. Pelham sent a message on Wednesday or not. She gave me a note indicating that she was adjourning Mr. DeLine to January 30th.
All right, in the matter of Barbara DeLine versus Benjamin DeLine, file number 14-40770 DM. That matter has been adjourned to January 30th. Thank you. All right, Janice and Michael. We got Janice. Scott. All right, let me get Ms. Gout connected to audio. Send Ms. Gout another message to connect. All right, Gilgannon and Green. All right, Mr. Gilgannon, thank you for your patience this morning. All right, this is in the matter of Brianna Green versus Dakota Larry Gilgallen, file number 2017-43922 DC. Mr. Gilgannon, we are here on a friend of the court show cause. States here that you're ordered to pay $256 a month in child support. And as of today's date, you have an arrearage in excess of $4,696. We were last here on September 26th of this year. And you reported that Casey Metal is your new employer. We sent out an income withholding and it was returned as never employed. I ordered you to pay directly to friend of the court when an income withholding is not in place. And the last payment we received was July 25th of 22 in the amount of $167. Do you understand that, Mr. Gilgallen? Mr. Gilgallen? Maybe he put me on hold. I don't know. All right, let's go back to Miss Gout. Miss Gout, in the matter of Janice Gout versus Scott Michael Gout, file number 2014-411.
Hello, I am here.
Oh,
Hello?
hi, Mr. Gilgallen. Hold on, Miss Gout. Go back to
Okay.
Sorry, I don't know what's going on with my phone. But no,
Okay.
I do understand that. I didn't get the job at Casey's, and currently I do have $600 I am going to pay you guys. I'm on my way to the courthouse right now. I tried to pay Friday. I did not realize you guys
Okay,
were closed.
Mr. Gilgallen, how far are you away from the courthouse?
I'm about like an hour.
Okay, so
That's why I'm calling.
how much are you gonna pay today?
At least 600. I might be able to borrow a little bit more, but I got 600 cash right now sitting in my lap.
Okay, all right, so Mr. Gilgallen, when you get here, I want you to go down to front of the court and I want you to pay. And then bring the receipt up to me on the 3rd floor, okay?
Okay. All
right.
Sounds good.
All right, I'll see you then. Thank you.
Thank you. Bye.
All right, so back to you, Miss Gout. Sorry about that. All right.
That's all right.
So this is a date and time set for show cause against Mr. Gout. He has failed to appear. So, all right, let's see. It looks like he returned to work. Have you seen or heard from him, Miss Gout?
No.
Okay. All right. All right. So notice was sent out to appear today. He has failed to appear. We received a payment in August. I will issue a bench warrant for his arrest for failure to appear. And I will set bond in the amount of $3,273.
Can I ask you a question?
Sure, I don't know that I can answer it, but I will try.
Okay, it's just really hard financially for me with him doing this and then we keep going back and forth. Is there any way that he can get a loan and pay me off or?
Ma'am, I am not a bank and I cannot give lending information or legal advice. So,
Okay.
you know, he can do a lot of things to pay it off if he chooses. I don't know. So, ma'am, you know, I guess he could, but if he doesn't have good credit, he probably can't. So, all right.
Okay,
So thank you, Miss Gout. We issued a bench warrant. You have a good day.
you too.
Thanks. All right, I got a prosecutor. All right, let me finish up my friend of the court stuff. Gilgallen, I just set over for later. Whoever has Gilgallen, oh, it's you, Mr. Vasquez. When he pays, if you just want to log in after that, I'll hear the case right then. All right.
All right, thank you.
All right, let's see. I got Jason, Marissa. Nobody's here. All right. In the matter of Marissa Clark versus Jason Gutierrez. Let's see. File number 19-46960 This is date and time set for a show cause. Mr. Gutierrez has failed to appear. To show that he has a monthly charge of $368 a month in child support plus $27 on the arrearage. And as of today's date, he has an arrearage in excess of $13,000 and $13,018. The last payment we received was August 23rd of 2022 in the amount of $91.61. We'll issue a bench warrant for his arrest for failure to appear. And we'll set bond in the amount of $4,000 cash. All right, I think that concludes my friend of the court show causes.
Should I just wait for the Anthony Ely case or?
If you want to wait a minute, you can. Miss Adams, were we able to find a public defender?
Yeah, Rhonda was meeting with somebody and then she was supposed to be popping in.
Okay. All right. Yeah, if you just want to hang out a second.
All right.
Spencer. All right. Okay. All right. So, Mr. Murphy, Mr. Fleming, I have Brandon Nodine. Present. Mr. Fleming, are you there?
I am, Judge.
All right. So this isn't, do you need a breakout room with Mr. Murphy, or I know this is a Miss Muir file. Are you up to date? It was set for a plea today. Do you need to talk to Matt, or are you guys good?
I don't believe so.
Okay.
As long as Mr.
Yes,
Murphy has the current offer.
Okay,
it's no
so in the
contest
matter
to
of the
plead
people of the
fourth.
state of Michigan versus Brandon Nodine, file number 22-20885FH, I have Matthew Murphy appearing on behalf of Mr. Nodine, who has appeared via Zoom, and I have Christopher Fleming appearing on behalf of the people. This is a date and time scheduled for a pretrial conference. Is this? Why is this Old Saver file?
Judge, you had it Wednesday and moved it to today.
Oh, yeah, okay. So, Mr. Murphy, it's my understanding your client wishes to enter a plea today?
Yes, Your Honor. The offer from Ms. Meir is for Mr. Nodine to enter a no contest plea to fleeing and eluding fourth degree and domestic violence first offense with an agreement for no upfront jail.
Okay,
He does wish to accept that offer today and enter no contest to that.
all right. And Mr. Murphy, are you prepared to place factual basis on the record?
I am, Your Honor.
All right. So, Mr. Nodine, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
And can you state, you can put your hand down. How do you, can you state your full name for the record?
Brandon Charles Nodine.
All right. Now, sir, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention, is that the plea as you understand it as well, Mr. Fleming? I'm sorry.
It
I forgot
is,
about you.
Judge.
Okay. So, Mr. Nodine, is it your intention to plead no contest to fleeing and eluding fourth degree and domestic violence first offense?
Yes.
Okay. And fourth degree is a 2-year, is that correct?
Yes, Your Honor.
Okay, and there are license sanctions as well?
I
Yes,
believe so.
All right, okay, and then all right, so is that your intention to plead no contest to those counts then, Mr. Nodine?
Yes.
All right, are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes.
All right, and you understand the maximum penalty for fleeing and eluding third degree could be up to 2 years in prison, and the maximum penalty for domestic violence first offense could be up to 93 days in jail. But there is a Killebrew agreement to no upfront jail. Do you understand that?
Yes.
Okay. All right. Now, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than no upfront jail. Is that correct, Mr. Fleming
that's correct, Judge.
and Mr. Murphy?
Yes, Your Honor.
And Mr. Nodine, as far as you're aware, is that correct?
Yes.
All right. If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
And do you understand that the fleeing and eluding third degree could carry up to a 1-year license suspension?
Yes.
Okay. So, sir, and I believe you're entering a no contest plea, so you're going to have to say no contest, okay? If
Right.
you wish to plead no contest. All right. So, sir, how do you wish to plead to the charge that on or about March 19th of 2022 in the city of Hudson in the county of Lenawee that you did commit the offense of police officer fleeing fourth degree?
no contest,
Okay, and on March 19th of 2022 in the city of Hudson in the county of Lenawee, how do you wish to plead to the charge of domestic violence first offense?
no contest,
Okay, and oh, look, you guys even gave me a police report. Okay, has anyone made any threats or promises to you to induce you to plead no contest to this charge?
no,
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
yes,
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming?
No, Judge, thank you.
Mr. Murphy?
No, Your Honor.
All right. Has your attorney promised you any other particular sentence or estimated what your sentence will be, Mr. Nodine?
no,
Is it your own choice to plead no contest?
yes,
All right. So, Mr. Murphy, I guess I do have a police report. I guess you probably provided that to me because do you want me to read through
I
it?
can establish the factual basis if
Okay.
you want to, Your Honor.
Go ahead.
That's fine. Again, this is taken from a police report that was from Hudson City Police Department. I think it's case report number 2100011357. And this actually stems from October 23rd, 2021. The investigation wasn't completed until March of this year. But it says that on October 23rd of 2021 in the city of Hudson, that an officer Keck came into contact with a red Dodge Avenger that was being driven by Brandon Nodine. He made contact with that red Dodge Avenger because it had a license plate that was for a Cadillac. He tried to pull the vehicle over to investigate, and the vehicle refused to pull over and in fact accelerated. The vehicle and the police officer were driving on Meridian Road heading north, and they ended up going on to traveling at speeds of 85 miles an hour or plus was what the police officer estimated, maybe up to 100 possibly. The chase ended south of Addison Village because the officer decided they were not going to be able to continue it safely. During the police chase, the officer did observe, or prior to the police station, I'm sorry, the officer had observed Mr. Nodine and a female who was later identified as Brittany Tucker. Mr. Nodine and Miss Tucker were in a dating relationship at the time on October 23rd, 2021. And they were actually in a dating relationship for some time after that, for a few months, maybe into March of this year. The officer did observe, and Miss Tucker did confirm in a later interview, that Mr. Nodine and her were having an argument. They were being very loud, and that during the argument, Mr. Nodine had slapped out of her hand. The officer didn't know what it was, but Miss Tucker indicated that he had slapped some food, a salad, out of her hand. I believe that would establish the factual basis for both a fleeing and eluding fourth degree and a domestic violence first offense against Brittany Tucker.
Okay. Are you satisfied with that, Mr. Fleming?
People are satisfied, Your Honor.
Okay. All right. So based upon the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that you said the fleeing and eluding actually happened in October of 21.
Yes, it was October 23rd of 2021 was when both the domestic violence and the fleeing and eluding occurred. It was on that day.
Okay. On that day that the defendant did commit the offense of fleeing and eluding fourth degree by driving away from a Hudson police officer after being given notification, and that he slapped an item out of the hand of the victim in this case, and therefore he did commit the offense of fleeing and eluding fourth degree as well as domestic violence first, and the court does accept the no contest plea. Has the court complied with the MCR 6.302 B, C, and D? Mr. Fleming?
Yes, Judge.
Mr. Murphy?
Yes, Your Honor.
All right, I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Killebrew agreement, this court has made no agreement regarding the possibility of a plea or possible sentence. In this case, with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. So, Mr. Murphy, this is a Judge Olsaver file. And I remember there was a reason we adjourned it to today, probably because I wasn't able to verify Judge Olsaver's schedule. Does that sound about right?
Yeah, we had worked out, I mean, it was scheduled for trial tomorrow in front of Judge Olsaver, but you had covered the final, or we had worked it out, and you had adjourned it to today because we couldn't get a hold of Mr. Nodine in time to get him in on
Okay.
Wednesday.
So, Mr. Nodine, you do have a right to be sentenced by the judge that took your plea. I took the plea today just to accommodate you so that a jury wouldn't have to come in tomorrow. So do you want to waive your right to be sentenced by me and be sentenced by Judge Olsaver?
I mean, it doesn't matter. I mean,
Okay.
today, I mean.
Well, I
just always
can't
do it.
sentence you today, but you have no objection to being sentenced by Judge Olsaver? Is that yes?
Yes,
Okay, let me call and get a sentencing date.
Judge, I have a date.
Never mind, because Becky's like
And just to
always,
confirm, Mr. Nodine, you're okay with doing sentencing over Zoom?
yeah.
I haven't gotten to that, but thanks,
Oh,
Mr.
sorry.
Murphy.
Okay.
Okay, so does Judge Olsaver do Zoom sentencings?
Yes, Your Honor.
Okay, so Miss Adams, what date did you get?
January 19th at 8:15.
All right, so sir, we're gonna set this for sentencing in front of Judge Olsaver on January 19th at 8:15 in the morning. So,
All right.
Mr. Nodine, you do have the right to be present in person for sentencing. Due to Zoom and changing the court rules, you can now Zoom in for sentencing if you so choose. So do you want to
All right.
appear in person or via Zoom?
I'll just do Zoom because
Okay.
I have to get a ride from my mom, so.
No, I understand. It's much more convenient. And since you're not looking at any upfront jail, that does make a difference. So I'm going to put you in a breakout room with Miss Holly from the Michigan Department of Corrections. She's going to give you instructions on how to proceed with the pre-sentence report. You will have to come to the courthouse for a
All right.
meeting with them. Now, when you meet with Michigan Department of Corrections, I want you to be truthful about your background and also the events that occurred. And we will see you back on January 19th at 8:15. So I'm going to put you in a breakout room with Miss Holly. Are you a veteran by any chance?
No,
Okay.
Judge, I'm sorry. Was that fleeing added count 5? I'm not sure if you stated that.
Probably because I didn't. So I don't think I have an amended information.
I've requested that amended, Judge, and we are adding count 5, fleeing 4th degree.
And
Thank
then
you.
count 6 domestic violence.
Well, we could just use count 2 on the domestic violence.
Oh,
Let's
okay.
get
it's
rid of the
already out
second
there. I'm
offense
sorry.
notice.
Okay, so count 5 domestic violence and count 2, or no, count 2 domestic violence and count 5 fleeing and eluding 4th degree. All right. So Miss Holly, I am going to put you and Mr. Nodine in a breakout room. So when you get the invitation to join the breakout room, Mr. Nodine, go ahead and join it. So hold on. Mr. Murphy, thank you. And Mr. Fleming, thank you.
Well, thank you,
Judge.
Your
have a
Honor.
good day
Thank you
here.
for accommodating Mr. Nodine this morning.
Not a problem. Mr. Nodine and Miss Holly, you should have gotten an invitation to join a breakout room.
All right, everyone have a good day. Thank you. Mr. Nodine, just contact me later. Thanks.
He's already gone.
No.
We will see you tomorrow, Judge.
All right, thanks.
Thanks.
Wait, for trial?
Yeah,
You and Mr. Murphy?
no, it's Mr. Daly.
Okay, all right. All right, thank you. Okay. Oh, wait. Mr. Ely, I have not forgotten you. Miss Underwood is down the hall doing a show cause, so if you want to just hang out for a minute, we'll be right with you, all right?
Okay, thank you.
I just didn't want you to think I forgot about you.
Okay, thanks.
All right, so I have Christina Hayes, can you hear me?
Yes, I can.
And David Hayes, can you hear me?
Yes, I can.
All right, do either of you have an attorney? No.
No.
No, ma'am.
Okay, so I'm gonna check something. All right, so this is in the matter of Christina Hayes versus David Hayes, file number 2011-36957 DM. I have both parties present via Zoom. And let me ask this, Mr. Hayes, your deployment ended, so you're back living in Lenawee County, right?
Yes, ma'am.
Okay, so I have an objection to referee's recommended order that was filed by Ms. Hayes, stating that hopefully the father has a new job position. I pay 100% of everything. I have the child 365 days. I'd like to claim the child on taxes every year. I now have a job, and so on. So when I look back, the last order from the front of the court had 0 overnights for Mr. Hayes, and that's not correct, because front of the court, well, that's the front of the court calculations were for 0 overnights, and I'm assuming that was because when he was deployed, obviously he couldn't exercise parenting time, but the last order I have gives him 96 overnights a year, which is like every other weekend, and summer parenting time. So perhaps someone can fill me in as to why there's 0 parenting time in the calculation. Ms. Hayes, you were shaking your head, so.
Well, he was like not deployed. He actually worked full-time for the military in Lansing. So he was in Michigan at home. But my child no longer goes there. He hasn't been there in a very long time.
How old is your child?
16.
Okay, and why doesn't your child go there?
I don't know, to be honest with you. I think just because he's at that age and he's a busybody and, all
Well,
over.
the order is dad gets 96 overnights, whether the kid goes or not, and he's supposed to go.
Yeah.
So I do think the child support was calculated incorrectly. Mr. Hayes,
Yes, ma'am.
any input?
So from, I'm in full-time military from 2020 to 2021. I was predominantly deployed forward for the COVID response. I did come back in Michigan full-time there. Sometime after this year, my son, Tristan, he's 16, said he didn't want to come over because it was a lot of hassle, for that time it was. My feeling is a lot of it's been the disciplinary stuff, not letting him do stuff with a crowd I'd rather not have him do with. So I'm going to talk with him about that, trying to get him back at the house. Understand I could go to the court and say, hey, that it's not being fulfilled. But I've been working with him, trying to just keep him engaged to come over. So the court does say 96 days on the
Okay, I'm going to stop you there, because whether the kid goes or not, he's ordered to go. So, right. I'm still going to give dad the 96 overnights because the kid's supposed to go. So ma'am, I wasn't quite sure what you're asking for.
I was just hoping that because the last the referee hearing stated that he had to pay only $200 and some a month now, and I was just hoping that he got a new job where that would state that he could pay more child support.
Okay, so ma'am, what happens is if he's receiving unemployment, we calculate child support at unemployment rate. Once he receives employment, he has to report that to front of the court, and then it would be recalculated. So sir, are you still on unemployment, or have you got that?
No, ma'am. I received the position and I submitted to the friend of the court my pay and all the documents I had to change that. And the friend of the court has submitted to my company the court order plus the insurance. So.
All right, so ma'am, I'm going to deny your objection to the referee's recommended order because he's already done that. So, yeah. And I'm also going to, hold on, I'm also going to order and send it down that friend of the court will also include in the calculation 96 overnights because he's entitled to that. And understand, if he were to show cause you could be facing jail for your child not going to his parenting time. So, your son needs to know that. So, all right, so I'm gonna deny your objection to the friend of the court recommendation because that's already been taken care of, ma'am. And then Miss McGrain will let them know that the calculation should be with 96 overnights. So, all right, so thank you both and good luck.
Thank you, ma'am.
Thank you. And Miss Adams, could you relay that? I don't know if I want to add it to the denial order or just notify friend of court. Okay, so I still don't have Miss Underwood, so hold on a minute. He's an attorney. I don't know what Teresa is.
Oh, Your Honor.
Hi, so Miss